So we ready to get started? Okay, everyone, welcome. Where this is a talk on natural law in the American political tradition. I think I have that right. I don't have the title in front of me, but that's approximately gets at it. So we're just going to give three 15 to 20 minute talks on various ways of getting into this question of how the founding fathers and how Americans, the heirs of that tradition, have made sense and have used the natural law and natural rights tradition in building and sustaining the American Republic. Then hopefully our talks will prompt you all to ask some either skeptical or probing questions, and we'll kind of have a little dialogue at the end. So I guess that's the agenda. Richard, are you ready to go?
Hi, everybody. So I think I might just kind of like, if I could just walk here a little bit and motion everybody here. My talk is a little bit about what nature, as Professor Rowe just sort of mentioned, how it plays a role in like our Constitution, our everyday lives, and how it actually affects us today. This has been a subject that has always fascinated me. It's actually what drew me actually after practicing law for a few years to want to come back to academia to talk about this, the biggest changes, how nature in particular is such a profound foundation. So the language I want to talk about today is about constitutional change, big constitutional change. And one of the things that is really interesting about the United States is that if we are, as I do believe, a nation based on an idea, then we have to recognize what that idea is, how those ideas take shape and form, and what contour they have, and how they appear in our regular life, and how we today in 2026 are connected to the original founding and Constitution, if we are at all. So that's kind of the topic. And the way I'm going to present this today is about the Constitution. The Constitution is our foundational law. It's based upon principles that we all agree upon, and essentially it lowers the stakes of politics. You can live your life knowing that your free speech rights, your rights of association, your property rights won't be influenced, hopefully on the next election or any election in the future. That's what good constitutions do. They lower the stakes of politics. So I've titled my talk, The Nature of Constitutional Moments. So one of the things that in constitutional law that in the last maybe 3 decades has been very popular is like, how do constitutions really change massively? What are the biggest transformations? How can we sort of look at those dynamics and sort of say something meaningful about how those dynamics actually work? I think that I've identified something that in the constitutional change and constitutional regime subgenre, a lot of scholars miss. And I want to sort of identify what they miss. But first I have to talk about what I'm talking about. So the first thing is like there's one constitution in place. It's created in 1787 in the summer months in Philadelphia, Pennsylvania at the Constitutional Convention. It's ratified. It has to be ratified by 9 of the 13 states. It gets that by 1789. The Constitution is the foundational law. It replaces the Articles of Confederation, which was in existence for 6 years prior, from 1781 to 1787. The Bill of Rights, which is what many Americans think of the Constitution, is added in 1791. These are the first 10 amendments to the Constitution. You have 2 more added a little bit after that. But then you have 3 very important ones. They come right after the American Civil War, bloodiest war in American history. More Americans die in the American Civil War than every other American war put together, in about a country like about maybe 7 or 8% the size of it today. It's the bloody war. A lot of those kind of lock-in features of a constitution are necessary, I would even argue. In 1865, 13th Amendment outlawing slavery, 14th Amendment in 1868, the most studied part of the US Constitution, the last of the 3, gives voting rights to the former slaves in 1870. Since then, you only have 10 new amendments that are actually in place. Only 10 since 1870. Really, you have 12, but prohibition's added and taken away, so it goes to 0. No new amendments have been added since 1992. By most metrics, this is unbelievable, incredible stability. It's one of the features, and remember, I started this talk by saying that constitutions that are good function as lowering the stakes of politics. You could plan your life. It's amazing stability formally. However, one of the things that the American constitutional law student, whether in political science class, that's an upper level class, or a constitutional law class, really learns is that we do have only one constitution since 1789. However, we do have multiple constitutional regimes. 3 of the major ones are the ones I want to talk to you about. I actually think that there's even inflections within these major regimes, but I do want to talk a little bit about each one to get to the topic of nature. This is what kind of I think is really interesting about nature. So the first one is the Federalist Constitution, ratified in 1789. I believe it lasted about 1861. The first president, George Washington, not given much credit by many constitutional law scholars. I think he deserves a lot more. I'm actually in a big minority in that. Most constitutional law scholars are enthralled by James Madison, and I'm unbelievably appreciative of James Madison, but doesn't get off the ground, either in Philadelphia in 1787 or as president during his 8 years without George Washington. That's why I put his silhouette. The founding, the crisis in the 1780s, we do have a first try at national government of the Articles for 6 years. A lot of problems, they start to mount up. That and the Articles of Confederation, the problems with them lead to the US Constitution. It's a second try. So, by the way, republics had always failed, both in ancient times and modern times, and this was going to be maybe no different if the first 6 years were any indication, but luckily the Constitution does kind of have a Republican remedy to the problems of republics. Second is what I would call the Republican Constitution. There's many names you could call it. I sometimes call it the Free Labor Constitution because labor is such a really big idea in the Republican Constitution. But just to be simple, I call it the Republican Constitution. It's a party born in 1854 to abolish slavery. It's the only third party in the history of the United States that becomes a major party within a very short amount of time. President Abraham Lincoln comes in. The Democrats are badly divided between their southern and northern factions. The American Civil War, the sectional crisis leading up to it. All of these things are extraordinary political events that lead to a kind of new constitutional understanding. Last of these, and these are the 3 major ones. I think you could also divide these into sub-regimes and inflections by Jefferson, Jackson, President Reagan. There's other kind of inflections on these, but these are the major ones. I would call them almost like first order constitutional changes. So the New Deal Constitution, I have to pick a date. I'm going to pick 1937. 1937 is this famous switch in time that saved 9. It's kind of like a big kind of story that we tell about the Constitution flipping in 1937. Some people say it's 1931 with the Nebbia versus New York decision. It's in the 30s. The New Deal Constitution, I would argue it's in the present. There's actually good arguments that maybe we're a little bit post-constitutional in some ways. I'm open to different ideas on this. A lot of this is backwards looking, so this is kind of what we call sub-regimes. President Franklin Roosevelt becomes president. There's the Great Depression, 25% unemployment. Big openings, founding, Civil War, Great Depression. These are arguably the 3 greatest threats to the American Republic at the time. People ask different questions when it's extraordinary political time. Oh. Oh. Just go back here. So the first thing I should clarify is, what is a constitutional regime? Super important question. I'm actually borrowing the definition by Yale law professor Bruce Ackerman. In 1991, 1998, he wrote the first 2 volumes of a series called We the People. He even has a 3rd volume. I believe the 3rd volume goes way off in a different direction than the first 2. But in the first of these volumes, what he calls We the People Foundations, he calls a constitutional regime the matrix of institutional relationships and fundamental values that formed a constitutional baseline in normal political life. What that really is are constitutional principles, an ideological orientation, partisan commitments, what the party in power is in favor of during that time, and institutional orderings. President, Congress, who's leading this kind of charge? Secondly, and very important, that these constitutional baselines, they constrain the options available to political actors within a given regime. They're kind of like how you play the game of politics. Between a particular regime, that is how you actually sort of like play the game of politics. Constitutional baselines are solid. They're stable. They only change when necessary. That's another sort of feature. Constitutional changes, therefore, are only triggered when there's an exogenous, a big time event, like an American Civil War, a Great Depression. And that kind of like makes people ask different questions at that time. One way to think about this is actually from my own model, which is slightly different from Ackerman's, but not totally. Articles of Confederation lead to the critical period and the American founding, the uncertainty of the 1790s. The Federalist Constitution comes in the midst of all of that. As you can see, the arrows pointing up here. You have Jefferson and Jackson have particular constructions, somewhat at odds with this original baseline. The American Civil War and all the things that lead up to it. You have a free labor or Republican Constitution. Later, as you enter the 20th century, you have alternative visions from the Progressive Era, the Great Depression, and what I would call the Revolution of 1937, and you have the New Deal Constitution. That's how this works. So you have, while we're not like France, that we have 5 republics, we actually do have these kind of like major regimes under one formal constitution. So how does this happen? There's many accounts. I want to just go over one major one. One major one. If like a student goes into law school and they might learn one of these kind of accounts, they'll probably learn this one. And this is from Yale law professor, again, Bruce Ackerman, and We the People. He has 3, but only the first 2, in my view, are actually consistent to his original model. And the 3rd one took like many years later. It's almost like 2 decades after the first 2. And basically, he says that there's a dualist regime in America by nature. He says that most of the time in the United States, you have normal political times where you have legislation on tax, regulation, other issues. But then there are these extraordinary times from political events, and they signal the need for higher lawmaking. He says that there are 5 stages. I'm just repeating what he says. This is not my model. Signaling, massive popular desire for change. That means like it might be a time for higher lawmaking. Secondly, there's a proposal from the public, and that's related by the political actors. So these goals become specific proposals for constitutional reform that are unbelievably different from what came before. Third, there's an impasse between the branches. We have a separation of powers. There's usually one branch that doesn't want to go with these changes. They hold firm. It's a constitutional showdown, an impasse, he says. Fourth, that impasse leads to more chances for the public to have an electoral mandate, an election, a reconfirming election, or what he calls a switch in time. One of the branches that is being obstinate, they blink. Lastly, you have consolidation. The higher law, the new constitutional law, is incorporated through the Supreme Court's rulings, and then that operates until the next one happens. What's interesting about this? We have in the United States, the founders gave us a way to make change. It's called Article 5. The amendment process they instituted. This is a constitutional law professor in the late 20th century saying that not only is this preferable, his model? But he makes another argument that's really interesting, that what constitutional change actually happens, it's always happened this way from the beginning. He says the actual Constitution, he kind of plays around with this idea, is illegal. Why is it illegal? Because the original Articles of Confederation needed all 13 states to be in union to get rid of it. Rhode Island didn't even show up in Philadelphia at all. So you can't even get that. So he plays around with that idea. Secondly, he has another one. He says, oh, the big second regime that the Republicans in Congress create after the Civil War. Well, the 39th Congress really kind of made it coercive for the Confederate states to come back into the Union. You have to accept the 14th Amendment. It's not like really voluntary. It's not like crossing the T's and dotting the I's properly. They're really roughshod with it, he says. And he has a pretty good kind of argument and the evidence that he shows that the Republicans were really playing hardball with the formerly Confederate states to come back into the Union. Third, he says, Justice Owen Roberts, he kind of sees the court packing threats and the switch in time in 1937. The Supreme Court blinks, and basically FDR gets his Constitution. Now, there are problems with this in terms of timing and thing, but this is one of the biggest stories in American constitutional law. And he's trying to sort of say that these kind of outside of Article 5 ways, that's how the Constitution actually changes. He also sort of says, very helpfully to us, that, and I think this is actually true, one of the things that he wants us to sort of understand is that lawyers need to strain history and political development in order to arrive at the conclusion that Franklin Roosevelt's Constitution is consistent with Madison's. Ackerman attempts to reconcile the New Deal within American constitutionalism by saying, hey, it was popularly agreed on by most people. So the New Deal, like the original Constitution, like Lincoln's constitutional changes, represented a legitimate interpretation of the Constitution because it was approved by the people massively through various stages. More implications. If the New Deal represents a legitimate constitutional moment or an extra constitutional amendment, then what the Warren Court did was correctly interpret that amendment. So it looks like the Warren Court making up a lot of law as it goes along. According to Ackerman, it's doing what it's supposed to do because there's a new third regime. And Ackerman's theory even enables him, says Keith Whittington, his colleague at Yale Law School today, that he's an originalist because each new regime is kind of like created on its own. So those are some of the implications of that. This is kind of the pattern. I kind of like see it a little differently, but it's not super inconsistent. A historical trigger opens constitutional space. An American president provides a constitutional vision. The new constitutional regime is constructed, and the Congress and the Supreme Court consolidate that vision. However, I think something's missing for it. And what is missing in that sort of idea is that essentially, what are these moments really talking about? And I think that they're talking about nature. Nature in particular is the one idea that is always changing in the Constitution. So most of these kind of like regimes are done by nature in one way or another, and that means that they're foundational. So most of what we're talking about in these constitutional changes are shifts in foundations. And it's perhaps why America might not witness a new constitutional moment for the foreseeable future. And what I'm trying to sort of say is that what's unique about America and America's Constitution is that America's Constitution is born of nature, it's completed by nature. Lincoln says we have this apple of gold on this pitcher of silver, that the pitcher of silver is supposed to hold the apple of gold, And that is the actual beauty of the American regime and the American constitutional kind of like photo, if you're going to sort of take it. And one of the things that we could learn about this kind of regime's kind of discourse is that one of the questions that people ask is like, why are people so interested in constitutional change? Well, one of the reasons people are so interested is that we started with nature, we completed nature, and in the New Deal, we overturned nature. And I think this is kind of like how nature is always playing a role in our most essential core values in the United States. Thank you very much.
Okay, so my name's Adam Rowe. I'm a professor here in history and law. My talk today is going to be about how natural rights discourse influences the debate, the American debate over slavery, both at the founding and then primarily in the antebellum period that leads to the Civil War. Before getting to that, I thought I'd make just a few general observations about natural law, of what we're talking about in natural rights. And I use these terms somewhat interchangeably because although there are questions about what comes first, right? The chicken or the egg, the rights, the law, these two things are obviously related, right? To speak of having natural rights implies that there are natural laws and obligations that govern these rights. And when we talk about natural rights, there's really about, I guess, three ways that what people are talking about. These things are often used interchangeably and are conflated in a lot of ways. One is to be speaking of natural law as the divine law, revealed law of God. It is the law of God. So James Otis, in one of his in his pamphlet on the rights of the British colonies, says that government has an everlasting foundation in the unchangeable will of God, the author of nature, whose laws never vary. Right. So here, like the most basic example of this is that human beings are made in the image of God, and therefore the rights that we have are rights because we are each equal in the sight of God. Right? That is a natural. That is one way of thinking about natural rights, is that it is through revelation. It's not through reason. A second, is, of course, is that natural law is immutable principles discovered in nature through human reason. Right? These are principles that we can reason about. We can understand them logically. You can have knowledge of these things through the use of reason and not through revelation. And someone like Thomas Aquinas, who's although he is a religious person, obviously, he does distinguish between what is revealed and what are natural rights, which are things that we can understand through reason. And I'll quote just Cicero's definition that's summarizing the Stoic view of natural rights and natural law, is that true law is right reason in agreement with nature. It is of universal application, unchanging and everlasting. There will not be different laws at Rome and at Athens, or different laws now and in the future, but one eternal and unchangeable law will be valid for all nations and for all times. Right? So there's an idea that human nature does not change, and therefore natural law does not change. What is right and just in one era, it does not depend. These things do not depend on what era you're in, what political regime you're in. Just conduct is eternal and immutable. And then finally, there is a way of thinking about natural law, which is that it is custom or law that is so deeply and well established and so universal in some cases that it is basically that this is seen as evidence from history, effectively, that it is a natural law. Right? So you can think about parents' rights to their children, or and children's obligations to their parents. These things, do not vary across time, right? Styles of dress, relationships between men and women. These things you can see certain differences, but there are other things that are kind of embedded, that are not just a matter of custom, right? Taboos against incest, right? You find these everywhere, and so these things are. When you look and find things that are so deeply established, we can kind of say that these things are basically natural law. And as I said before, these kinds of ways of thinking about natural law are used interchangeably, and they're also, I would submit, and this is that they are basically the three ways of arguing about politics, about critiquing politics. One is you are invoking a religious principle, right? You are saying we are all equal. This is not something you prove by looking under a microscope. It's not something you're making a basic kind of metaphysical religious point about human dignity, human equality, things like that. That you're not open to persuasion on these things, right? Another is to say, like, let's reason about this, right? Why this is what economists do when they say that, like, why you can't just give everybody more money, right? Is that this is not something that is, you don't have to rely on religious first principles. You can just see what happens, right? There's inflation, and the money becomes valueless, right? So that's another way of that the governments cannot just do whatever they like. They are subjected to certain constraints that are basically inherent in nature and in human nature. or something like communism, right? One can make an argument about it on first principles that it's wrong because people have a natural right to their property and their wealth. But you can also make basically like an empirical argument, like this just is founded on a misconception of human nature and simply will not work. And then you can look and say, did it work? And the answer is no, right? So that's a different basis. And then of course the third being arguments from history, just seeing what has existed in the past, and that gives you some evidence of what is changeable, what we can change in our societies, and what is basically fixed and immutable. Now the founding era is uniquely rich in natural rights discourse. And there's an obvious reason for this, right? Which is that during the founding, the founders were first invoking natural rights to resist British tyranny. They then invoked natural rights to right to revolution in order to overthrow the British government and to disavow any remaining obligations of obedience to their government, which they had formally recognized as their government. And then, as they frame constitutions and create new governments, they are having to use natural rights and natural law discourse in order first to kind of, as a standard for what would be a good government, obviously, and also they're invoking it very much in kind of, it is infused in the Constitution itself. So when we think about the rights that the Constitution protects, it is expressly, these are rights that the Constitution does not create. They are rights that it is recognizing, that they precede the Constitution. That is a foundational principle of our government. And when you look at even legal decisions by the Supreme Court and elsewhere, there is invocations of natural rights to kind of fill out what our understanding of the Constitution is and what it requires. And so this raises the paradox that I'm going to be talking about for the rest of today, which is how is it possible that this era, the early republic from the Revolution to the Civil War, is the era in which we have important political actors thinking most deeply about natural rights. And again, it's like when you look at the founding era, it's kind of astonishing to think. I mean, we're basically arguing over a Stamp Act tax, and like the pamphlet begins by like, what is the origin of government? What are the ends of government? What is the nature of man? And this is not like atypical. This is how they all start, right? They're all beginning with these first principles at this time in a way that like we still have political disputes about policy. We don't do that kind of reasoning anymore. And yet, at the same time that you have this really express preoccupation with natural rights, you have the coexistence of slavery and an acknowledgement among early Americans of this basically the existence of an institution created by positive law that is a gross violation of natural rights principles. So how do you kind of square that circle? And I'd say there are three broad phases of when you think about American attitudes and discourse about slavery and how it relates to natural law. In the first, which goes from basically the beginning of the colonies, 1619, the first slave arrival in America, to basically the 1760s, it is not a politically salient issue. It's not really being discussed except marginally. Now there are philosophical attacks on slavery. So Montesquieu says famously that like we have to. I'll get the quote right here. Says that it is impossible to suppose that these creatures slaves to be men, because allowing them to be men, a suspicion would follow that we ourselves are not Christian, right? So this is kind of our sarcastic line, and John Locke also has a critique of slavery as incompatible with natural law, but this doesn't have any real political salience. But then starting in the 1760s, as Americans begin to invoke natural rights principles in their opposition to Great Britain, this suddenly becomes a major issue. And there's a lot of finger pointing on both sides. So Dr. Samuel Johnson in Britain famously says, how is it that we hear the loudest yelps for liberty among the drivers of Negroes, right? So he's accusing the Americans of hypocrisy. Thomas Jefferson, in his first draft of the Declaration, effectively accuses one of his indictments of the king is for imposing slavery on the colonies as a kind of as a war against human nature. But it is becoming during this era, the Americans are addressing this as a real political issue, as an evil and an intolerable evil that ought and should be abolished in time, right? But here, the founders, and this is characterized their attitude towards slavery, but it's also true of them more generally. They are able to keep their eye on basic principles of natural right and natural law, and yet reconcile that with prudential considerations of what is possible right now, what is possible to maintain a stable political regime, right? And you know, you can think of all kinds of like any system of law is going to be in some ways an imperfect reflection of individuals' rights, right? In some ways, your rights are more protected under the government, but in other ways, it's going to impinge on people's rights. You can think about, I mean, an example of this would be like copyright law, right? You can think of this as something that does exist in nature in the fact that, or patent, right? You invent something, you create something, it's yours by some kind of natural right, right? Other people don't have the same right to it as you do. But obviously, in a state of nature, you can't protect this, right? You can't go around telling everybody, oh, if you use my neat little contraption, you have to pay me, a licensing fee. Obviously, that wouldn't work. And where this right, to the duration of this right, and things like that. These are questions of positive law and not really of natural law. But you can kind of relate them back to it. So at the founding and up through the early republic, basically, you have an awareness of slavery as a profound evil, but one that should be reformed within the existing system of laws. And the pattern on this is it is a strikingly similar, like basically in New England, where slavery doesn't have much of an existence. It's abolished very quickly. In the mid-Atlantic states, it's abolished much more gradually. And so it's only until the 1830s that like places like New York fully abolished slavery. And in the Deep South, the assumption up until about the 1820s and 1830s is that they're just taking a little bit longer, but they are also committed to the idea that this is an evil that must be eradicated. But then starting in the 1830s, you have a growing divergence. And basically what happens in the North, you have abolitionists who begin to say that slavery is a covenant with death and an agreement with hell, right? That it is it is a disgrace to the Constitution. The Constitution itself should be overthrown for its complicity in slavery. And you also have a few, a very marginal number who actually say that the Constitution itself requires the abolition of slavery everywhere. Now, it's very hard to reconcile that with the historical evidence, but it is a view. And then in the South, you increasingly get writers and thinkers trying to make an argument that no, slavery is not a violation of natural law. We are not guilty of a great crime. It is a component of natural law. It is a reflection of natural law. It is a blessing to master and slave alike. And I'll return to at least one of the most famous statements of that in a moment. But one thing that's interesting is that that's not the view of Abraham Lincoln and the Republicans who actually abolished slavery and saved the Union, right? They do not claim that the Constitution abolishes slavery everywhere. And they do not claim that the Constitution is itself a covenant with hell and an agreement with death, right? So how do they reconcile it? And with Lincoln, the basic idea, and there are two statements that I think best capture this with Lincoln. One is when he was a young man, and he writes of the founding generation. What they achieved was, he says, a practical demonstration of the truth of a proposition which had hitherto been considered at best no better than problematical, namely the capability of people to govern themselves. And he rephrases this with the all-important word proposition in his Gettysburg Address, where he says, 7 years ago, our fathers brought forth on this continent a new nation conceived in liberty and dedicated to the proposition that all men are created equal, right? Now, what he's done there is change what the Declaration said, right? In the Declaration it says these truths are self-evident. They don't need people to prove them. Right here he said this is actually something that people have to demonstrate, that most people don't see it. It's not self-evident. It has to be proven. And there's a conservatism that comes with this, which is that for Lincoln, this idea that people are equal and are capable of governing themselves according to law is a very fragile thing. And you cannot, the idea here is that in order to improve upon the principle of the Declaration of Independence, it is one that you have to use the legal system as it is. You can't simply assert your right of conscience to overthrow this right and to impose it. It has to be done under the law. And I'll read, one kind of interesting debate that captures this, which is from Lyman Trumbull, not Lincoln, who's another Republican, who actually writes the 13th Amendment abolishing slavery later on. And he is describing the Republicans' position with regard to John Brown's raid on Harper's Ferry, which was an attempt at a violent overthrow of the South's peculiar institution. And he says, no man who is not prepared to subvert the Constitution, destroy the government, and resolve society into its original elements can justify such an act. He said, all governments, the best of which have been devised, encroach necessarily more or less on the individual right of man, and to that extent may be regarded as evils. Shall we, therefore, destroy government, dissolve society, destroy regulated and constitutional liberty, and inaugurate in its stead anarchy, a condition of things in which every man shall be permitted to follow the instincts of his own passions, or prejudices, or feelings, and where then will be the protection to the physically weak against the encroachment of the strong, right? So he's saying to invoke the right of revolution basically leaves everybody free to do whatever they wish. And this is not a way to protect the weak. You need to rely on law. And Senator Clay of Alabama interrupts Trumbull to ask, like, how can you maintain that slavery is simultaneously immoral and lawful in some places? And he asks, would not the taking of human life without justifiable or excusable cause be a crime, independent of all statutory provision or legal enactment? And if so, by parity of reason, is not polygamy a crime? And if so, by the force of your own platform, which condemns slavery equally with polygamy, is that not a crime against all human legislation? Senator Clay asks. So how could you, if a crime is a crime, regardless of the law says it's a crime? And Trumbull says of this, he says, the taking of human life, in the instance the senator puts it, unjustifiably, would undoubtedly be a great crime and a crime in any civilized country. I do not know how it would be regarded among savages. In some instances, where we would not regard the killing as by any means justified, they perhaps would. Now, there are a couple of different ways to read this, but basically what Trumbull is saying is that self-government requires people to obtain natural rights on their own, not without outside interference. And so the states themselves are required to do that. But of course, the South is the one that ultimately overturns this compact and reverts effectively to the state of nature. And now I want to read, as a conclusion, Alexander Stevens's cornerstone address. And it's a little bit lengthy, but I'll try to go through it quickly because it does capture just how much Southerners did, in fact, commit themselves to not just to slavery, but to the idea that they were in conformity. Slavery was in conformity with natural law and eternal principles of justice. Stevens writes, the prevailing ideas entertained by Thomas Jefferson and most of the leading statesmen of the time of the formation of the old Constitution were that the enslavement of the African was in violation of the laws of nature, that it was wrong in principle, socially, morally, and politically. It was an evil they knew not well how to deal with, but the general opinion of the men of that day was that somehow or other in the order of providence, the institution would be evanescent and pass away. He continues, those ideas, however, were fundamentally wrong. They rested upon the assumption of the equality of the races. This was an error. It was a sandy foundation, and the government built upon it fell when the storm came and the wind blew. Our new government is founded upon exactly the opposite idea. The foundations are laid, its cornerstone rests upon the great truth that the Negro is not equal to the white man, that slavery, the subordination to the superior race, is his natural and normal condition. I'll skip ahead, but he goes on to say, the great objects of humanity are best attained when there is conformity to his laws and decrees, in the formation of governments as well as in all things else. Our Confederacy is founded upon principles in strict conformity to these eternal laws. It has been apprehended by some that we have arrayed against us the civilized world. I care not who or how many they may be against us when we stand upon the eternal principles of truth. If we are true to ourselves and the principles for which we contend, we are obliged and must triumph. Just as a concluding point, it was actually Alexander Stevens who wrote to Lincoln and encouraged him to say some soothing words to the South, to reassure them that he wasn't going to interfere with slavery, that the Republican Party was not quite as anti-slavery as it seemed. And Stevens concluded this admonition by saying, a good remark from you will be as an apple of gold in a picture of silver, right? And it is that encouragement from Stevens that prompted Lincoln to say of the Declaration that it is the apple of gold in the picture of silver, which is the Constitution. And what Lincoln means is that what Stevens is asking him to do is to reassure the South by not insisting that slavery is wrong. And Lincoln is saying, if I do that, I'm surrendering the thing that makes the Constitution worth saving in the first place. Right? So that is how he came to think of the Constitution as the picture of silver containing the apple of gold. Thank you.
Okay, well, I don't have a presentation, but I am going to stand up. I'm like Winston Churchill. If I'm not standing, I'm lying down. So I don't like to sit. I'm going to talk about natural law and the early state constitutions. And I want to add something to Adam's remarks here on natural law. Why are we talking about this subject? Well, if you look at the nature of human beings, we live in particular moral and political and social frameworks. We have a particular order that we belong to with customs, laws, traditions, beliefs that we tend to hold without even thinking about them. We assume that there's something that is good and correct. But the problem with that is that when you look at different human societies, you see those laws and customs are different in different places. There's certain laws and customs and beliefs that tend to be the same, right? Prohibitions against murder and theft and things like that. But there's also many differences, right? If you look at, Herodotus gives a famous example that some peoples bury their dead, others cremate them or even eat them, right? Well, how can we judge those different customs? How can we understand them? The great political philosophers of the Western tradition all believe that you can look to nature, right? You could try to uncover some understanding of human nature by which we can then judge particular governments, particular laws, and particular moral and political frameworks. And so that's what the American founders were thinking of when they thought of natural law. This is a standard by which we can judge the relative goodness or badness, the relative legitimacy or illegitimacy of a government. And the most famous expression of this, of course, in American political history is the Declaration of Independence. Right? The first sentence of the Declaration opens with this claim that there is a law of nature and of nature's God that grants us the right to form a separate and equal station among the nations of the world. Right? And the second line of the Declaration of Independence famously says, "We hold these truths to be self-evident, that all men are created equal, endowed by their Creator with certain inalienable rights, and among these are life, liberty, and the pursuit of happiness." When the founders are thinking of the law of nature, there's two particular things that are especially important when they're framing their political order. Right? One, the purpose of government, which I just said, and it's protection. It's protection of those natural, unalienable rights. Right? A government is not legitimate unless it is preserving your right to life, liberty, property. The right to acquire and possess property is one of the rights that's often stated. The right to pursue happiness. But secondly, the founders said that this law of nature also means that just governments are formed by consent. The next line of the Declaration is that to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed. But that means for a government to be fully legitimate, the people who are governed have to consent to it. They need to have some means by which they can say, all right, this government is doing what we want it to do. And this is the purpose of a constitution, as Professor Esquerdo explained earlier, right? If a constitution lowers the stakes of politics, how does it do that? Well, by one, it serves as a mechanism to secure consent, right? And when a government no longer is able to protect rights, when it is no longer doing what it's supposed to do, the Declaration then says that people have a right to alter or abolish that form of government and to institute a new one that is best conducive to preserve their safety and happiness. Now, the issue, though, with the Declaration of Independence is that what is the Declaration doing? It's separating the United States from Great Britain. And so the Declaration has this beautiful expression of what natural law or the law of nature meant, but it doesn't clearly show us what now the new government is going to look like. And of course, we can look to the federal Constitution, we can look to the Articles of Confederation, but I'm going to argue that we should actually look to the early state constitutions. Right, for one thing, most of the real governing that was happening in early America was taking place at the state level and at the local level. And also, these early constitutions do a couple of things for us. One, as I'll explain here in a moment, these constitutions often began with expressions of the principles of government. Right? What do we hold to be just? What is our understanding of justice? We'll see that's derived from nature, ultimately. Right? What can human beings know about ourselves through the exercise of our reason? The early state constitutions discuss these principles of government much more clearly and more substantially than the federal constitution does. And second, it's in these state constitutions where the rubber hits the road. It's where we can see what did natural law really mean for the actual exercise and practice of government. And so I want to talk first about how are these constitutions created. For the most part, these constitutions were created through conventions. They were created through town meetings in which the peoples of each state got together. They debated different drafts of the Constitution, which was often recommended by their legislatures, and they voted on whether or not to ratify that Constitution, much as would later happen with the actual federal Constitution. In cases where this did not happen, for example, in Connecticut and New Hampshire, the first constitution in both of those states was not actually sent to ratification conventions. That was considered a defect. And it was a defect that was quickly remedied by their later constitutions, right? Because they said, well, if the Constitution is going to be the supreme law that governs the people themselves have to directly consent to that law. And for the most part, that's what happened in these early states. I want to take the example of Massachusetts. Massachusetts is the origin point of the war in 1775. After the war breaks out, even before the Declaration of Independence is signed, the state governments are beginning to form and to revise their colonial charters and to form new constitutional systems they believe are more compatible with the natural law and are better fit for the sort of republican framework of the United States, right? The self-governing character of the American people. And the Continental Congress is sending advice to these state legislatures saying you should really begin to form your own state constitutions. Massachusetts in 1778, the legislature proposes a constitution and sends it to the people to ratify. And the people hold a vote and they hold a series of meetings and deliberations in their towns on whether or not to ratify the Constitution. They ultimately reject it. They ultimately say this Constitution does not fit, it does not fulfill the purpose of creating what's going to be a stable and just political order. And one of the interesting things that happens in this debate over the 1778 Massachusetts Constitution, I'm going to read here from a statement that was written by the representatives of Berkshire County. In Berkshire County, the representative said, "We consider our case very extraordinary. We do not consider this state in all respects as in a state of nature, though it be destitute of such fundamental constitution." Right, when we're thinking of the law of nature, one of the concepts that comes to mind very often is the state of nature. Right, if you're thinking of early modern political thinkers like Thomas Hobbes and John Locke, this is how they derive their understanding of natural rights and the purpose of government. And when we hear that phrase state of nature today, there's certain misconceptions that often occur. Sometimes we think of the state of nature as a hypothetical. Right? We try to imagine what would human beings like in some sort of alien foreign region where there's no government, there's no civilization, how would we act? Right? We think of a Lord of the Flies style scenario. Or another way that sometimes people think of the state of nature is they think of it as some sort of prehistory, right? They think of it as the primitive origins of human beings, and from there we derive some understanding of how we evolve and form political communities. But the way the founders thought of that phrase state of nature is they simply meant what human beings operate under, how we live if we are living outside of a functional civil government, right? Imagine that you have a state of anarchy, right? The government is overthrown or the government just collapses overnight. What would it actually look like? Well, the founders believe that in a state of nature we have a moral law, right? They believe that nature gives us a certain guidance of how we are supposed to live. It gives us certain rights and certain corresponding duties. But the problem with the state of nature is that our rights are not protected. This is why we ultimately form governments. Now, another thing I want to point out to you in this Massachusetts debate, so the people in Massachusetts rejected the 1778 Constitution. The next year, a new constitution was devised. It was written primarily by John Adams, and it was submitted to the people who then ratified it in 1780. And this is actually the oldest operating constitution in the United States. It's one of the oldest operating constitutions in the world. The 1780 Massachusetts Constitution still exists, although of course it's been greatly amended and revised over the course of the last 250 years. But during this debate in the 1780 Constitution, there is a particularly useful document that was created by the people of Essex, Massachusetts. This is called the Essex Result. And it was written by a young lawyer named Theophilus Parsons. Has everybody heard of Theophilus Parsons? He's one of those founding figures that nobody really hears of today. He was very important. He would later become the Chief Justice of the Massachusetts Supreme Court. He was one of the leading jurists in the Federalist Party. And he was also the mentor to John Quincy Adams when JQA became a lawyer. Parsons, in this work, The Essex Result, gives what I think is really the most comprehensive account of natural law in the American founding. He begins with the problem of anarchy and tyranny, right? And he's thinking, following the line of John Locke and some other political thinkers, where he says, well, all right, if human beings begin in a state of nature, that state of nature is obviously not good in many ways. We would rather live under a good civil government. But then he goes on to say, on the other hand, that state of nature is probably better than tyranny, right? In the state of nature, your rights might not be protected, but at least you've got a fighting chance. You don't have any chance under a tyranny. And so Parsons says that as we're starting to think of governments, we have to try to create a government that's going to protect those natural rights and at the same time be limited in order to ensure that a tyranny does not emerge. And Parsons says in this work, he says, all men are born equally free. The rights they possess at their birth are equal and of the same kind. Some of those rights are alienable and may be parted with for an equivalent. Others are unalienable and inherent, and of that importance that no equivalent can be received in exchange. Sometimes we mention the surrendering of a power to control our natural rights, which perhaps is speaking with more precision than when we use the expression of parting with natural rights. But the same thing is intended. When men form themselves into a society, a body politic, or state, they are to be considered as one moral whole, which is in possession of the supreme power of the state. The supreme power is composed of the powers of each individual collected together and voluntarily parted with by him. No individual, in this case, parts with his unalienable rights. The supreme power cannot control them. Each individual also surrenders the power of controlling his natural alienable rights only when the good of the whole requires it. Parsons actually capitalized those final words. Your rights, to the degree that any of your natural liberties being surrendered, is only when the good of the whole requires it. The supreme power, therefore, can do nothing but what is good for the whole, and when it goes beyond this, it is usurping power. Right, so this is how the founders were thinking about the establishment of our early constitutions. Right? You need to surrender some of your natural liberty, but it's for the sake of protection, ultimately. The better protection of your life, liberty, and property. And there's a difficulty in this, right? Parsons goes on to say that in order to have political happiness, in order to have a good political community, on the one hand, you have to get the principles of justice right, but on the other hand, you also have to think of what's the condition of your people. What kind of government are they able to accept? What types of laws are they going to accept? Right? What prudentially can you do given your circumstances? One way you could think about this is Solon, the famous ancient Athenian lawgiver. Plutarch in his Life of Solon. The Solon was known for his famous quips and sayings, and one time Solon was asked if he gave the people of Athens the best laws. And his reply was, no, I gave them the best laws that they could accept. Right? In other words, you have to be thinking of both the principles of justice and also what is the actual conditions on the ground? What is your circumstances of your people? And the early state constitutions show us how the framers and founders were thinking of both of those circumstances. Bless you. And so what do you see in these early constitutions? Well, first, most of them began with preambles or declarations of rights or bills of rights, which explain the principles of government. And they explain this with more precision and thoroughness than what you see in the Declaration of Independence. Right? Certain common themes that you see in these declarations of rights were that human beings are born equally free and independent. Right? So that we're not equal in all respects. We're equal in the sense that we are born free. We have certain inalienable rights. And that means that government has to come about through the consent of the governed. Also, these declarations of rights said that the primary purpose of government is protection. Right? It's the enjoyment of these natural rights and the pursuit of happiness. Right? So government was not established to do everything. There's certain things government can do well. That's primarily law enforcement. Right? It's protecting you against crimes. It's preserving property, creating an order in which you can create contracts, and you know those contracts will be fulfilled, preventing fraud, theft, deception, things like that. The second part of these governments, of course, is what we think of when we think of constitutions. Right? The early state constitutions would create frameworks of government. And this is where we get to the separation of powers. Powers were separated, legislative, executive, and judicial, for the sake of creating a government that could actually secure rights. Right? A government that would be limited to doing those things that government is supposed to do. Now, a third part of these state constitutions is moral formation, right? The cultivation of certain form of a way of life and a certain character within the people. And this is why some scholars, such as Gordon Wood, argue that the founders were more concerned with the creation of the public good, the creation of the common good, and with promoting a sort of citizen virtue. They were more concerned with those things than they were with protecting natural rights. But I would argue that both these things, right, the creation of a sort of virtuous republic and the protection of rights, all this is really coming from the natural law doctrine that the founders held. The idea is that if you cultivate certain morals, certain virtues in the people, you're then better able to protect their rights. And how did the state constitutions do this? Well, they had certain provisions. One, most of the state constitutions have provisions for promoting education. They had provisions for creating militias as opposed to professional standing armies. So they believed that militias would be better able to protect republics, and that militias would also inspire and cultivate discipline and bravery and courage within citizens. You had laws against vice in the early states, laws restricting gambling, prohibitions on prostitution, things like that, right? Certain vices that could ultimately lead to violations of rights, right? Take prostitution, for example, right? If prostitution is running rampant, then you could have children born out of wedlock, right? Who's going to actually protect them? Who's going to ensure that those children are reared properly? Right? This is why you had certain vices. This is why the founders thought of them as vices, because these are ultimately going to make it more difficult for government to do its job and for the people as individuals and as a collective to actually pursue happiness. Also the ordinary enforcement of law, right? We don't think of most legislation as legislating morality, but it ultimately is. When you have laws that are effectively enforced against murder, when you have laws enforced to protect contracts, that promotes a sense of justice among the people. Finally, one area in which the constitutions disagreed on is religion. All the early states agreed that religious liberty is necessary, that it's one of these unalienable rights. They agreed that a broadly Christian population was best able to maintain self-government and the protection of rights. Even the non-Christian founders like Thomas Jefferson actually agreed with this, which is kind of interesting. But the state constitutions disagreed on what the scope of religious liberty meant and to what extent should government actually provide public support for religion. In Massachusetts, for example, the government explicitly provided financial support for churches. In other places, such as Virginia, which very early on created a statute of religious liberty, you had more disestablishment. And so there you get into an area in which there was not a clear consensus within the founding. But to conclude, if you look at these early state constitutions, this I think gives you the fullest expression of what natural law meant at the time of the founding and how it actually was not simply some sort of abstract principle, but was actually the core, the center that allowed for some sort of concrete, stable, and I would say ultimately good political order. Thank you.
Great. So do people have questions? Yep.
Dr. Sarah, you said that we're kind of, some people argue we're moving out of the New Deal's constitutional regime. At what point do you, or would people argue that switch is, and where are we heading towards?
Great question. It's also a great question because a lot of these kind of models, both in politics and constitutional, are backwards looking. You have to have enough data to sort of make a judgment and assessment. My argument is that we probably are at the end of constitutional moments because our Constitution is premised on nature as a foundation of which we derive natural rights, as my two colleagues have explained in some detail, and I tried to sort of say that's the unique feature of America. And the founders also looked at it as like a philosophical or scientific subject, a question of unchanging permanent right. And Lincoln, when he's approaching it, he's sort of saying, this is a big gap. This is my opportunity to bridge that gap. New Dealers come in, and the New Dealers sort of, because the progressives denied natural right, every single progressive did not believe in natural right. There's not even one that believes in natural rights. They actually, all of them criticize it, and then they don't get an opportunity to change the Constitution totally because there's not an opening. The Depression allows that, and today we have a different Constitution because natural rights is part of our Declaration, it's part of our tradition, it's part of our political heritage, it even resonates in political speeches. At the constitutional level, it's gone. I don't like saying that, but it is gone. I mean, you have parts of it in the First Amendment and other rights, but it's just gone. And so now I sort of think that the next constitutional moment has to be really innovative because my whole thing was that every single constitutional moment is either making nature our foundation, completing it and reaffirming it, or declining it. The next one would have to be like resuscitating it. And I wish there was evidence to show that. I just don't see it. And so there are really interesting arguments that we may be at a post-constitutional age in which we might not have the premises of democratic supremacy and all of this stuff that the New Dealers were really, by the 50s and 60s, the Warren Court is using some of that for economics and property and going in different directions. And we may be at an anti-foundational age. So the gist of my talk is that all three moments are defined by nature, creating it, affirming it, rejecting it. And I don't know if we'll have a fourth moment. But I don't know. This is a backwards-looking model. Great question, by the way.
Any other questions? All right. Well, thank you all so much for coming, and have a good, enjoy the rest of your day.